Since I couldn't upload videos for last 1.5 weeks, today I'll be giving you two surprises. I think one surprise because I am uploading two videos today, so I hope you will like that. One is a request that was made by a subscriber, and this video, the other one, is on a very important concept. It is very important as a lawyer, as a law student, to distinguish between bail, parole, furlough, temporary release, permanent release, release after conviction, release post conviction, pre conviction. And this video is about two such important concepts, which is parole and furlough. Hi guys, this is Isha Kapoor and you're watching Vlawgish. Just about 10 days back, on October 20th, 2021, a very important judgment was delivered by the Honorable Supreme Court of India. The bench consisted of two honorable judges, Justice Chandrachud and Justice B.V. Nagarathna. The judgment was authored by Justice Y.V. Chandrachud. Justice Y.V. Chandrachud, according to me, is known for writing judgments which appear as a book, as a thesis to you, from which you can learn a lot of things, not only about the case, but about the concepts involved in the case. And this was another such judgment. It was given in the case of Narayan Sai. Narayan Sai's furlough application was rejected multiple times, and therefore he had to reach the Supreme Court of India. He contended that furlough should be granted as a matter of right to him, that my furlough application should not have been rejected merely on the claims of me being involved in illegal activities inside the jail, such as keeping a mobile phone, or merely after saying that it would not be in the interest of society. Since he is an influential person, he has a lot of fan following outside the jail, in the general world, and he may tamper with the evidence or influence the witnesses. If he is allowed to go on furlough, if he is released from the prison for a few days. So the Supreme Court utilized this opportunity. Justice Chandrachud, Justice B.V. Nagarathna utilized this opportunity, and what they did was they gave us a very good judgment on the difference between parole and furlough, and in this video I will explain you that difference. First of all, I must let you all know that both these concepts, parole and furlough, they come into picture after a person is convicted of a crime. This is not applicable to under trial prisoners. So all those who are under trial may be released on bail, but all those, of course, bail can also, there are certain circumstances in which bail is also granted post conviction. In CrPC, you can refer to the relevant sections of the CrPC, but we are just talking about parole and furlough for now. The Supreme Court clearly informed all of us that furlough cannot be granted or cannot be claimed as a matter of right. They said that furlough can be restricted. The release of a prisoner on furlough can be restricted on the basis of interest of society. Since it's my last video in the month of October, I must tell you about the UNACADEMY's offer that is ending today. So UNACADEMY has an offer for all the students who want to pursue judiciary, who want to give PCSJ exams. If you will purchase the 24-month subscription by today, you will get a 4-month subscription free on UNACADEMY. And even if you want to purchase subscriptions which are of shorter duration, then you can purchase a 12-month subscription, as they have just told me, and you will get a 1-month subscription free. If you purchase 18-month subscription, you will get a 2-month subscription free. I have already told you about the test series, the free test series that is going on UNACADEMY, and a lot of students opted for it. They have told me that the tests are structured in a really nice way, and they are able to learn from it. They are able to get clarity on what kind of questions can come in the judicial services exam, and how will they be required to approach them. A lot of students told me कि कभी-कभी ऐसा होता है कि हम एनालाइज नहीं कर पाते कि कितना टाइम चाहिए और किस टाइम, उस टाइम को हमें किस सेक्शन में स्पेंड करना है. उन्होंने मुझे बताया कि इन सारी चीज़ों को UNACADEMY के जो टीचर्स हैं, एक्सपर्ट्स हैं, वो बहुत अच्छे से एक्सप्लेन करते हैं. अगर आप लोग को भी लगता है कि आपको इसको ट्राई करके देखना है, तो मैं बता देती हूँ अभी कितने सारे बैचेस चल रहे हैं UNACADEMY के. आप उनमें से कोई भी बैच को चूज़ कर सकते हो, एंड यू कैन स्टार्ट योर प्रिपरेशन टुडे. नोबडी इज स्टॉपिंग यू फ्रॉम दैट, बट इफ़ you do that, do use the code Vlawgish to get a 10% off on the subscription that you will be purchasing. They said that it is not an absolute right of a prisoner post conviction to be released on furlough for 2 weeks after serving a particular continuous period in jail. They said that if the authorities feel that the person can tamper with the evidence, can influence with the witnesses, and it would not be in the interest of the society to release him on furlough, the furlough can be rejected. Furlough or parole. Parole is one such concept for which reasons are required to be given. If a prisoner is to be released on parole, and you are placing an application for release on parole, then there should be some reasons in that application. You just cannot say that I deserve to be released on parole just because I have served this much of my term sentence in jail, and now I think I deserve to go outside the jail for some time. No, that cannot happen. If you want to be released on furlough, give a reason, such as your ailing mother outside, your ailing father outside, or anybody from the family of yours needs your help, needs your guidance, needs you to take care of them, or maybe you have to attend a function which cannot happen without you. Mark my words, if a prisoner is going outside the jail on parole, the term on which he remains on parole is not counted in the sentence served in the jail. सो अगर किसी प्रिजनर को 3 वीक्स के लिए पैरोल पे रिलीज़ करते हैं तो आपको ये समझ लेना होगा कि अगर उसकी सज़ा, उसकी पनिशमेंट 5 इयर्स की थी तो उन 5 इयर्स में से वो 3 वीक्स कम नहीं होंगे, यानी कि अब उसे जो सेंटेंस सर्व करना पड़ेगा वो होगा 5 इयर्स 3 वीक्स, क्योंकि 3 वीक्स तो वो बाहर रह के आया है तो उसे पूरे 5 साल जेल में कंप्लीट करने होंगे। पैरोल पे दिया हुआ वो टाइम काउंट नहीं होगा जेल में रहने के टाइम के लिए। बट अगर मैं फरलो की बात करूं तो फरलो में बहुत ज़्यादा रीजंस की रिक्वायरमेंट नहीं होती जो कि पैरोल में होती है। फरलो क्या होता है, वो टेम्प्ररी रिलीज़ दी जाती है कुछ टाइम के लिए जेल से, और इसके पीछे का जो ऑब्जेक्ट है ना वो ये है कि क्योंकि प्रिजनर ने पोस्ट कन्विक्शन बहुत ही अच्छा अपना कंडक्ट मेंटेन किया, उन्होंने कोई इलीगल एक्टिविटी नहीं की, कोई इन्फ्लुएंस करने की किसी को कोशिश नहीं की, वो ऐसा दिखा रहे हैं कि वो रिहैबिलिटेशन की तरफ जा रहे हैं, वो ऐसा दिखा रहे हैं दैट द प्रिजनर इज ट्राइंग टू बिकम एन एसेट टू द सोसाइटी, देयरफॉर ही डिजर्व्स सम remission, therefore he deserves some gift from the authorities and you can take that gift as फरलो। तो अगर इजीली समझना है तो फरलो को एक गिफ्ट समझना, पर गिफ्ट भी किसे दिए जाते हैं? क्या हम गिफ्ट्स उन लोगों को देते हैं जो हमें बिल्कुल पसंद नहीं होते, जो हम बहुत प्रॉब्लमेटिक होते हैं सोसाइटी के लिए, मुझे बहुत परेशान कर रहे होते हैं? वुड यू लाइक टू गिफ्ट anything to any such person? No. So furlough gift is not a matter of right, and therefore furlough is also not a matter of right. If you are showing that good conduct, then you will be released after you have served a particular amount of time in jail. जेल मैनुअल अगर आप देखो या फिर जैसे कि इस केस में बॉम्बे प्रिजन रूल्स डिस्कस हुए थे, वहाँ पे भी यही है कि फरलो के कॉन्सेप्ट को जहाँ डिस्कस किया है वहाँ पे भी कुछ रूल 3 एंड रूल 4 में उस पर लिमिटेशंस भी लगाए गए हैं कि अगर अथॉरिटी को लगता है कि सोसाइटी के लिए ठीक नहीं रहेगा अगर कोई इलीगल एक्टिविटी की हो जेल के अंदर, तो फरलो नहीं दे, वो ये भी बोल सकते हैं कि नहीं हम आपको फरलो नहीं देंगे। और अगर फरलो देते हो तो कोई रीजंस की भी इतनी रिक्वायरमेंट नहीं है। सिंपली अगर मैं एक प्रिजनर हूँ, पोस्ट कन्विक्शन में अच्छा से कंडक्ट मेंटेन कर रही हूँ, तो इट इज़ ग्रांटेड टू मी ऑन द बेसिस ऑफ मी बीइंग रेगुलर, मी बीइंग कंसिस्टेंट विद गुड कंडक्ट, and it is granted to me to break that monotony of me being a prisoner, of me being inside jail, इसलिए भी कि कहीं मेरे सोसाइटल टाइज बिल्कुल ही सिवियर ना हो जाए। ऐसा ना हो कि जब मैं अपना सेंटेंस सर्व करके बाहर निकलूँ तो मेरे पास कोई मेरी वो कैपेसिटी ही ना बचे, मेरा अपने फैमिली मेम्बर्स से, मेरा अपनी सोसाइटी से, अपने रिलेटिव्स से कोई लिंक ही ना बचे। तो उन चीज़ों को मेंटेन करने के लिए भी फरलो को ग्रांट किया जाता है प्रिजनर्स को पोस्ट कन्विक्शन। फरलो के लिए जो आप सेंटेंस आउटसाइड द जेल सर्व करते हो, जनरली वो 2 वीक्स के लिए मिलती है फरलो, बिकॉज प्रिजन मैनुअल और प्रिजन रूल्स में यही लिखा है, जनरली 2 वीक्स के लिए दी जाती है। तो अगर आप बाहर जाते हो उस टाइम पे, वो जो आपका पीरियड है, क्योंकि वो गिफ्ट की तरह से मिला है तो वो आपको ऐसे ही माना जाता है जैसे आपने उतना पीरियड जेल में सर्व कर लिया। तो अगर मैं फरलो पे 2 वीक्स के लिए जेल से बाहर रह के आती हूँ, देन अगर मुझे 5 ईयर्स की पनिशमेंट मिली हुई है तो वो 5 ईयर्स में मुझे 2 वीक्स एक्स्ट्रा सर्व नहीं करने पड़ेंगे. इफ़ आई हैव सर्व्ड 1 ईयर इन जेल ऑलरेडी एंड नाउ आई एम रिलीज्ड ऑन फरलो for 2 weeks, then after 2 weeks when I come back to jail, I will be treated as a prisoner who has served 1 year and 2 weeks inside the jail, and who has served for that much of imprisonment period. And if you want to know more about these concepts of parole and furlough, you can go on and read the cases of State of Maharashtra versus Suresh Pandurang, and another case of 2017, that is Ashfaq versus State of Rajasthan. Both these cases were also discussed by the Supreme Court of India in this recent case, from which I have got a lot of knowledge about the concepts of parole and furlough. So parole is temporary release, furlough is also temporary release. Both are granted after conviction, post conviction. These are the similarities between the two. But if you are being released on parole, that can also be restricted on you being an habitual offender, on you being a threat to the society, or on your tendency to commit that crime again if you are released on parole. Being released on parole, a parole application certainly needs some strong reasons for you to be released on it. So, but furlough is like a good conduct remission. As I told you, it's kind of a gift that is given to you. एक इससे बहुत ज़्यादा मिलता जुलता कॉन्सेप्ट है रेमिशन का. Remission is granted under section 432 of the Criminal Procedure Code. If you want to know exactly what remission is, you can go to that section. But for your knowledge, I must tell you that remission is granted when you make an application to the government, and in that regard government can also consult judges on the same. They can go to the judges and ask for their opinion on whether you should be released from the prison, whether your sentence should be reduced, whether you are such a prisoner who deserves such empathy, whether you are a threat to the society or not, how's your conduct inside the jail, what kind of offenses did you commit, and all of that. So remission क्या होता है कि आपके offense के period को, आपके imprisonment के period को थोड़ा कम कराने के लिए या आपको early release कराने के लिए जो एक application आप लगा सकते हो गवर्नमेंट के पास, और जिस पे गवर्नमेंट आपको ग्रांट कर सकती है, बट ऑन कंडीशंस. दे विल इम्पोज सर्टेन कंडीशंस ऑन यू और बोलेंगे कि अगर आप ये कंडीशंस फुलफिल करोगे तो ही हम आपके सेंटेंस को रेमिट करेंगे, रेमिशन को ग्रांट करेंगे. अगर आप इन कंडीशंस को फुलफिल नहीं करते इवन आफ्टर योर रिलीज ऑन रेमिशन, देन ऑल्सो द रेमिशन ग्रांटेड टू यू कैन बी कैंसल्ड. दैट विल स्टैंड कैंसल्ड इन दैट केस, और आपको फिर से प्रिजन में बुलाया जा सकता है. I hope after watching this video, your basic concepts related to these terms, parole, furlough and remission, are clear. If you like such videos, you can tell me in the comment section below, and I will meet you again very soon with a new video on a new concept. Bye for now.